I am Zoe Frost with Celebration Magazine Live, and we are here today for a Zoom and Learn with Brendan McGee from McGee Law Firm. Now, he is going to be doing a really interesting talk today. Now, I know that we said we were going to be talking about understanding the basics of your estate plan, but we're going to work that information in with information about the 8 ways that people destroy their estate plan and what to do about it, because not understanding the basics is definitely one of the ways that you can destroy your estate plan. So Brandon's going to be going over all of that. Brandon, make sure you take yourself off mute, and the floor, my sir, is yours.
Okay, guys, so we're going to talk about how people destroy their estate plans and what to do about it. So as I go through this information, just kind of be making a mental checklist. I'm going to present 8 different ways that people that mess up, destroy their estate plans, and just kind of be keeping a checklist. Are you currently in the act of doing that? A little bit about myself here. So I am a DFW native. I have an office. I have 2 offices in DFW, one in downtown Fort Worth, one in Southlake. I have clients all over DFW and different parts of the state as well. In this day and age, we, do some Zoom and remote consultations and so forth. So I've got clients in different parts of the state. I went to TCU, attended Emory University School of Law in Atlanta, Georgia, and I'm a member of a couple of national organizations that we're going to talk about. Also, I've been licensed since '02. So actually coming up in November, it will be my 20th lawyer birthday, which I can't believe that. It's gone way too fast, but almost 20 years. I'm a member of the American Academy of Estate Planning Attorneys. And this is a national organization based out of San Diego, California. And really what's important to know here is a couple things. Number one, the Academy does not allow just any attorney who wants to join the organization. We're limited by region. I'm really proud right now to be the member in Dallas-Fort Worth area. There's some other members in Texas and many throughout the nation. But we're all highly vetted before we're allowed in. So when you're talking with an American Academy attorney, it's an attorney who focuses on estate planning. It's not an attorney who practices 3 or 4 different areas of the law and then does this on Monday or Tuesday. Estate planning, elder law, this is what we do day in and day out. It's the focus of our law practice, which I think is important in this day and age. Also, we're a member of NALA, the National Academy of Elder Law Attorneys. This is a large national organization. They do let in any attorney who's willing to cut the annual dues check. So I didn't do anything super special to get accepted into this one like I did in the American Academy, but it's still a great organization that gives me a really good network of attorneys all across the state and the country, and keeps us up to date on current trends in the law. We're also a member of the Better Business Bureau. And then I'm going to talk for a moment about why I'm an estate planning attorney, because as you guys know, just like a doctor or an engineer, there's lots of different things I could be doing with my law degree. So I think it's kind of important to know what led me down the path of being an estate planning attorney. And so this is my family here. This is my wife, Rita, who's actually a real estate attorney, and then our fraternal twin sons, Cole and Hunter. And it's actually some things happening in my family is what led me down this path. And so that's why I put this picture up here. But in the first 10 years of my law practice, like I told you, I've been practicing for about 20 years now. I had a heavy litigation caseload. So I was a trial attorney, and that's what I wanted to do when I applied to law school, when I was studying in law school. When I got out of law school, I wanted to be a trial attorney. I thought that sounded fun, sounded exciting. It sounded like what lawyers are supposed to do, right? They're supposed to be in court fighting big battles. So that's what I did. And for 10 years, as I was doing that, I had a kind of organically an estate planning and probate practice started to build up with clients asking me, hey, can you draft this for me? Can you probate a will? So I grew this just accidentally, really, this smaller estate planning practice. And what I really always liked about estate planning, though, as opposed to litigation, was estate planning gives me the opportunity to help families set up their legal affairs so that when bad things happen, right, we're all going to pass away. Some of us will go into a nursing home. Some of us will lose our mental capacity. Some of us have big medical episodes. But when these bad things happen, what gives me a lot of happiness is knowing that my clients, their families are set up to handle it in the best way possible, the quickest way, the least expensive way, and most importantly, the least stressful way, which is generally going to be avoiding the court system. So in about around the year 2011, let's say, my kids were 3 at that time, my twins. I started to get kind of burned out on the trial work. It's high stress. It can be some weird hours at times, some weeks, strange hours. Also, a lot of times when I would go home, even though I was physically home, I was not mentally home. I was mentally at my office thinking of all these things I need to be doing to get prepared for trials and hearings and so forth. So I started thinking, like, I just don't know that I want to do this for the rest of my life. But I didn't really, had built up a large enough practice. I didn't really kind of have the guts at the time to find a way out. So just kept doing it. Well, in 2012, in May of that year, late May, my wife Rita was diagnosed with stage 3 breast cancer. And so for any of you who have been through this diagnosis in your family, particularly with somebody that's relatively young, we were, in our late 30s at the time. It was a big ordeal, and our twins were just about to turn 4. Rita was running a law practice. I was running a law practice. So just a really shocking situation, like how is this happening to us type event, right? But then Rita started chemotherapy very quickly. And then about 35 days after her diagnosis, at the age of 64, my father, on July 1st of 2012, on a Sunday, was in his backyard in Dallas, Texas, and he came in the house and I guess kind of put himself on the hardwood floor and laid there. My mom saw him and said, what's going on? What are you doing? And he said, well, I have a really bad headache, and I'm just not feeling very well. So my mom, suggests, well, you're in your 60s. We have, you have heart disease in your family. Maybe I should call an ambulance or take you to the hospital. And my dad, being a good male, said, no, we don't need to go to the hospital. We don't need to call the ambulance. Just help me get into bed and give me some aspirin and let me take a nap. Well, unfortunately, my father never woke up from that nap. And so that day, my dad passed away. My mom went to check on him 10, 15 minutes later, and we're pretty sure he was gone at that point. She called the ambulance. So within 35 days, my world had been kind of turned upside down. My wife has stage 3 cancer and is going through chemotherapy, and my dad is gone. So very unexpectedly, all of this was super unexpected. So it got me thinking through the rest of the year that, we might as well in life, we don't know when our last day is. Time is precious. Time goes very fast. You might as well, Brandon, get up every day and do what you enjoy, and not spend the rest of your life doing something that you kind of wish you weren't. So I made the decision coming out of that year that I was going to convert my practice into estate planning and elder law. It was a huge risk. It was scary, but it ended up being one of the best decisions I've ever made in life. So that's what led me to that point. That's what got me that was the catalyst to get me to follow what I enjoyed, what I loved doing, which was estate planning. And most importantly, this past October, Rita was 9 years, no evidence of disease. So that's the best news of all. Okay, that's about me. That's why I'm an estate planning attorney. Now let's get into the law, because that's why you're here. We will do a question and answer at the end. So please jot your questions down. Not concerned about your cell phone, because this is by Zoom, so not worried about that. So let's talk about this. 8 different ways people can destroy their estate plan. Okay. Number one, it's important to know, we all need estate planning documents. What documents we need? There are some that I feel everybody needs. A last will and testament and powers of attorney. we have a series of a package of 7 that we provide our clients with when it comes to powers of attorney. But I tell everybody, even if a man who lived under a bridge came to see me for a consultation, I would still tell him, you need a last will and testament, and you need a set of powers of attorney. Okay. However, the legal language can change in documents. The legal system goes on and on and on and on and alters and changes. And a lot of people also move states and they don't pay attention to that, and they don't get a review of their estate plan. So if your documents are more than 7 or 8 years old, if you have brought your documents in from out of state, you really want to have a review of those. Okay. So we've had a lot of people that unfortunately have to come in after a loved one has passed or become mentally incapacitated, and they find out that their documents are insufficient, and we either can't get them through the court system, or I've got several files right now we're trying to get through the probate court that are just an absolute nightmare because of the estate plans were in poor shape and were neglected for so long. Okay. And again, unfortunately, some people don't find this out until it's too late. What you don't know can hurt you in the law. But that saying, what I don't know, or if I don't know that, these 3 people that I think are my friends are out talking bad about me, it's not going to hurt me because I don't know. Well, when it comes to legal issues, you're eventually going to get hurt if there's things that you don't know. Okay. It's the cleanup work. Like I said, can be very expensive. It can cause family arguments. And that's one of the big things that we're trying to avoid in estate planning is family feuds. And that's one big reason to get a good, comprehensive, detailed estate plan in place, particularly if you're a blended family. Just so you guys know, that can be a red flag in our industry that a family really needs some good, well thought out estate planning to avoid big arguments and potentially legal battles between stepkids and step parent, or stepkid versus stepkid. Okay. So mistake number 1 is going to be not keeping up with changes in the law. Most of our laws for estate planning in Texas are through our state system. So estate planning laws are the domain of each state. So there's 50 different jurisdictions. So if you've moved in from somewhere else, another state, you really need to have your plan reviewed by a Texas estate planning attorney. Okay. Whether you've moved in or not, though, you need a regular check-in. We offer our clients every 2 years. So from the date a client signs a plan, every 2 years, we will offer for them to come in free of charge. It's complimentary, and I'll sit down with them and we'll review their life. We'll review if there's been any changes in the law, so we can keep up with that. If somebody said to me, look, I'm not going to come in every 2 years, I'm just too busy for that. Just what's kind of the bare minimum here? I would say at least every 5 years, guys, have your estate plan reviewed by a legal practitioner. Okay. There are some federal laws that will impact estate planning, mainly in the issue of taxation, and also more recently, the amount of time it takes or the amount of time that you have to withdraw retirement dollars after somebody's passed. And we'll get more into that. But 90% of estate planning, if not more, 95 is Texas law for us. 5 to 10% is going to be federal law. And all those laws are subject to potentially change. Here's a little chart for you, modern federal estate tax changes. You just get the point that, hey, the estate tax threshold, it changes. The percentages, it changes. So you guys to keep up with, things going on with the IRS and Congress in Washington, D.C. We all know these things can change depending on administrations, depending on which party's in power in Congress, right? Secure Act. So one key change that you guys should know about if you don't, in December of 2019, by some miracle, all 3 branches of the federal government were able to agree on some changes to our retirement assets. And what they agreed to was that after somebody passes away who has retirement assets, meaning traditional IRA, 401k, any assets that we have to pay income tax on as we withdraw, then the next generation, once they inherit them, they are going to have to withdraw these funds within 10 years, meaning I can't, if I inherit money, if I inherit a 401k or an IRA when I'm 50, I can't wait till I'm 70 to start withdrawing that money. I have to withdraw all that money by the time I'm 60. Okay. So that's something important to keep in mind. Also important to keep in mind that the smart person will withdraw 10% a year over 10 years. That way they're minimizing the tax bracket they're in. But we have 10 years as of December of 2019 to make those withdrawals. So some other little changes here with that. Employer tax credits to offer IRA plans, early withdrawals up to 5,000 allowed for birth or adoption, just some minor things there. And then new IRA inheriting solutions. So there are some things that we can do with our IRAs to try and minimize taxation, avoid taxation. I'm not going to go into great detail on all of these, or else we would be here till this evening talking about the whole slideshow. But there are things such as charitable remainder trust, turning a traditional IRA into a Roth IRA. There's also some things that we can do through life insurance policies that if you guys are interested, you can have a follow-up meeting with me. You can research on the internet. I say that with a grain of salt. Be very careful, because I have people coming in telling me all sorts of things that they see on the internet. But there are options out there to help minimize both the estate tax exposure and the income tax exposure on retirement assets after somebody passes away. So there's, again, different things that we can do. If you have somebody named other than your spouse named as your primary beneficiary, they have to take out the inheritance within 10 years. Your spouse does not, okay? Doesn't apply to a spouse. I have some clients that will set up a trust and they will name their trust as the beneficiary of their IRA. The money still has to be withdrawn within 10 years, but the trust can pay the tax obligation and the money can be distributed whenever the person wants. So if I have somebody that I don't want them getting my retirement for 20 years, for whatever reason, it could be a grandkid, it could be an adult child who's just been irresponsible, I can have the trust go ahead and withdraw that money after I pass. The trust will pay the taxes. The money will sit in a trust account, then be distributed. Okay, planning mistake number 2 is when an estate plan is not updated to reflect family changes. So we have changes in the law, which can obviously be a really big deal for an estate plan. We also have family changes that occur, and it can be all sorts of things. And this is another thing that I address big item that I address at my 2-year reviews, is what's going on with your family. Have any of your kids gotten divorced? Have you had new grandkids? Have you had a falling out with anybody that's involved in your estate plan, your backup executor, your backup trustee, your backup power of attorney? So all these sorts of things can happen. And so we need to reflect this in the estate plan. If you have your older brother was your backup on all of your documents and he's now deceased, or he's now had a diagnosis of dementia, we obviously need to take him out and put somebody else in. If you had 2 grandchildren and you left them each $50,000 to use for college, and then you've had 2 more since we drafted the plan, we obviously need to put the new grandkids in there. So different things that can happen. Again, we need to stay on top of the people who are in roles of authority after we die, after we lose our mental capacity. If I lose my mental capacity, it's my power of attorney who will be handling my documents, who will be handling my matters for me. If I get Alzheimer's, if I have a bad stroke, if I have a head injury, that power of attorney is going to be making my medical decisions, consulting with doctors, paying my bills, handling my finances, doing everything I normally do for myself. So we want to make sure that the people that we listed there, that we still like them, number one, that they're still alive, that they still like us, that they still have their mental capacity. We need to make sure they didn't move to Japan, right? Want to make sure they're hopefully more or less local, but at least US based, if not regionally local. Another thing about powers of attorneys is I recommend about every 5 to 6 years to redo them, because the laws can change fairly rapidly in this area. So you don't have to get new ones every 5 to 6 years. I want to be clear on that, but we recommend it. So please keep that in mind. I have people that come in and they say, oh yeah, I have powers of attorney, and they're, from 2003. And, they're running a huge risk that if they lose their mental capacity, they may not work at Bank of America, or they may not work at Charles Schwab or Baylor Scott and White Hospital. So they may be rejected. So we want to keep on top of that. Successor trustee changes, who's going to be in charge of your trust, or the executor under your will if you have a will. Is it your old business partner who you used to be great friends with and y'all got along great, then he started drinking heavily, and your business broke up and you forgot to change him out of your estate plan, and now you've got your drunk, belligerent ex-business partner still heavily involved in your estate plan if something should happen to you, right? Or your son-in-law, former son-in-law, let's say, who used to be a trusted member of the family, and then maybe didn't treat your daughter well, and she ended up getting a divorce, and did you come to me and get him out of the estate plan? So we need to pay attention to change in dynamics and relationships in our lives. Like I said earlier, new beneficiaries, right? Babies being born. I have some clients who they have an adult child who marries somebody that already has kids. And then my clients are the step grandparents, but they become really close to the step grandkids, and they want to include them in the plan to some degree. All sorts of different things that can be going on here. Unfortunately, I have from time to time clients that have falling outs. Will have a falling out with their adult child. It's really sad. And they need to come see me and say we need to remove him or her for now, and we hope things change. We're going to be coming back to you, Brandon, and putting them back in, but for now we need to take them out in case something happens to us. So these things happen in life. Something else to pay attention to that's very critical: special needs beneficiaries. If you have a special needs grandkid or a special needs kid, if this is somebody that's probably going to end up on Social Security, disability, and Medicaid to help them pay for just their basic needs in life going forward, you do not want them to inherit money from you, because they will be, for lack of a better term, kicked off of Medicaid, kicked off of Social Security, disability, until they spend down all of that money. And then they can be let back on, they can reapply once they're broke again. So what we do for special families of special needs beneficiaries is we set up a special needs trust. We make that trust the beneficiary, not the individual themselves. And when the parent passes, or the grandparent passes, they inherit that money through the trust. There's a third-party trustee who manages it on their behalf, and they're able to keep their Medicaid, they're able to keep their Social Security, disability, and the trust is there to pay for certain things allowed by federal law. So it's a great situation for that special needs individual. They'll keep all their funding from the government that they need to meet their minimum bills, and they'll have a little bit extra that can be used for things like clothing, food, things like that. Marriage or divorces, right? People getting remarried, people getting divorced. Those are big ones that can signify we may need a change in our estate plan. A change in assets. I have so many people that come in to see me and they've neglected their estate plan for 20, 25 years. And it's a lot of people that do that. So if you are that person, don't feel terrible, do something about it, take action, but don't feel terrible. I have a lot of accomplished clients that come in and they sort of hang their head in shame, and they show me their old estate plan from 1995, when their kids were 4 and they lived in North Carolina. Now it's 2022, they live in Texas and their kids are, 30 something. They, and they were worth $200,000. Now they're worth, $2.8 million. All sorts of things have changed, but particularly when assets change, you may start needing a higher level of estate planning, moving into having a trust, things like that. So maybe some tax, looking at some tax avoidance mechanisms like we kind of talked about a little bit earlier. So a dramatic change in assets can also call potentially for a change in the estate plan. Planning mistake number 3, no plan to avoid nursing home costs. This is a big one. 50% of Americans who reach the age of 65 will end up in a nursing home at some point. The average stay is 22 months. The average cost right now in DFW, you can easily spend $7,000 a month or more on a long-term care stay, skilled nursing, memory care. Okay. So there are some families that on both extremes, you have the extremely wealthy that they don't have to worry about this because they have enough money. It just doesn't matter. If they have to go into care, they'll pay for it. It's not going to be a big deal. We have other families, they have so little money that those spouses will qualify for Medicaid, the government funded payment for skilled nursing right out of the gate. They're not going to have to spend down their retirement to get there. They're already there. So, but most of us, the vast majority of people that I talk to are probably going to be somewhere in the middle, right? So most Americans, most Texans are going to be somewhere in the middle. And you really want to think about this because there are a lot of families who have lost almost everything, hundreds of thousands of dollars, which may be their total net worth, that they'd like to leave to their spouse or they'd like to leave to their kids that they were not able to. So we're going to look at this a little bit. Like I told you, it's about $80,000 a year now to stay in a nursing home in DFW. Just imagine, $7,000 a month coming out of your account every month, right? And imagine, especially if you have a spouse, your spouse is still at home, having to pay bills, having to live their life, having to live the normal life that you once did, and pay this $7,000 a month. Okay. Different ways that we can pay for the long-term care stay. Number one is use your own money. If you have no other plan, that's what you have to do. Number two is buy long-term care insurance. This is not for everybody. I do recommend that the majority of my clients take a look at it and see if it is a good fit for you, because if you end up having to go to assisted living, skilled nursing, or memory care unit, and you have an insurance hook on the policy to pay for that, it's a good thing. That being said, some people are at an age where you're just not going to get it. Other people are at an age where it's just not affordable. Some people have past medical issues where to the point that it's just not, you're not going to get insured based just simply on your medical issues, regardless of age. But it's a good thing to look into and see if it fits for you. Number three, some people say, well, I know what, I'm just going to use Medicaid. I'm about to apply for that. I'm getting that soon. If I have to go to a nursing home, I'll use that. Medicaid will only pay for a short-term 30-day stay. Medicaid is not going to pay for a long-term prolonged stay. Okay. So after you've been in there for 30 days, so it's mainly people who are doing a rehab type stay. They broke their hip, they had a knee replacement, they have to learn to walk again. They stay for 3 weeks, maybe in a care facility. That's what that's for. So don't think that Medicare is a solution. It's not. Now, Medicaid is a solution potentially, and Veterans Aid and Attendance Benefits is a solution. However, with VA aid and attendance, it is not for all veterans. It's for veterans that fit certain criteria, one of which is spending time in a war zone. So you need to, if you're a veteran or the spouse of a veteran, go to the VA now and find out. What we don't want to do with any of this stuff, guys, that a lot of people do, unfortunately, is wait till the last minute. Your husband had a stroke, a massive stroke. He's on day 3 in the hospital, and they tell you, look, he has permanent mental impairment, physical impairment. He's never coming home. In 2 or 3 days, we're going to release him. He's going to have to go to skilled nursing. You're going to be in an emotional whirlwind. The last thing you want to do is have to go through this analysis, contact the VA, get in to talk to me, and go through all this while you have 72 hours and your life is an emotional whirlwind. You want to do this now before there's problems, while people are still calm, and emotions aren't crazy. All this estate planning, preparing for long-term care, plus the other things that need to be done to prepare for death, prepare for mental incapacity. So please do all these things ahead of time. Medicaid, that's sort of when all else fails and you're pretty much broke, let's apply for Medicaid. Okay. They have a set of complex rules, not easy to navigate. I don't recommend doing it without the assistance of an attorney, but you can give it a shot. But Medicaid basically has 3 criteria. You have to have medical necessity for round-the-clock medical care. That's going to be a note from a doctor, a report from a doctor stating that. Your assets, let me see if this is, yeah, we're about to get to that. So your assets have to be below a certain threshold, and your income has to be below a certain threshold. And we're going to look at that. But first, for assets, there's two different kinds of assets that Medicaid will divide everything into. And for purposes of Medicaid, we love non-countable assets. That means they don't count it. It doesn't count. You can have that, and they're not going to deny you Medicaid. Number one is a homestead in value up to $595,000. So that's a good thing for us in Texas. It is not that way in every state, and Medicaid laws are different by state, guys. So if you move from another state, if your sister in New Jersey has been telling you this and that about Medicaid or estate planning in general, please take it with a huge grain of salt, because it may not be correct for Texas. But we can have our homestead up to $595,000. We can have our personal things. One vehicle per married person in the house, per spouse in the household. An irrevocable prepaid funeral plan for each spouse is allowed. A life insurance policy with an equitable value up to $1,500. Some annuities, these are Medicaid compliant annuities. They're generally irrevocable annuities. They're very rare. There's not many. Most people that have them, it's because they sought them out on purpose. Most annuities are countable, but a select few are not. Traditional IRAs, this is in the last 2 years. It's been a huge help to Texans. If you are 72 or older, you have a traditional IRA, you are taking your RMDs the way you're supposed to. It's non-countable as an asset. Okay, so it's good for us. What is countable? Everything else. Any property above and beyond your homestead, any motor vehicles, registered motor vehicles above and beyond one per spouse, checking, savings, CDs, Roth IRAs, 401ks, investment accounts, stocks, bonds. So everything else in the world is countable. Okay. Now, what are the limits for assets? If I'm a single person, I'm not married at the time that I apply for Medicaid, I can only have $2,000 in countable assets. Not a lot, right? It's not leaving much for my family. If I'm married, I can have $128,420 in countable assets. They're leaving a small cushion for that marital spouse. But for a lot of people, they're still not happy with that. They've got $500,000 nest egg. Husband has to go into care. The wife doesn't want to spend that down to 128. She may live another 10 or 12 years, right? It's a very scary thing for some families. Married couples in long-term, if God forbid they're in there together at the same time, it's $3,000 in countable assets. Now, if I'm over this threshold, does that just mean that I'm done in? I'm gonna, one day if I have to go into care, I'm just going to be spending out all my money, and when I get to one of these levels, then I can get Medicaid. Fortunately, the answer is no. There's something called a irrevocable Medicaid protection trust. If we set that up, if we put our assets in that trust, 5 years later, that's key, 5 years later, because there's a 5-year look back, those assets are non-countable. Okay. So, but there is a 5-year look back, but that's the solution for that problem. Income cap for a single person is $2,349. And this is a monthly income cap. For a community spouse, it's $4,698. So if you have 1 penny, guys, if you have 1 penny over any of these monthly amounts for income, 1 penny over the asset level, Medicaid will deny you, literally 1 penny. Now, if I have too much income, let's say I'm a single person and I have $3,500 a month in income, does that just mean I will never apply for Medicaid and I've just got a big problem? The answer is no. We can set up something that's called a Miller's Trust, and we can reroute a portion of the income into that trust so that it doesn't hit your account, it hits the trust account, and then you can qualify for Medicaid once that process is done. Okay. It's important to remember, though, that you cannot use the money that goes into that trust account. Okay. You can't just have it and start spending it. It's going to sit there, and when you pass away, it's going to go to Medicaid. Medicaid will get that money, but at least you siphoned off $1,000 a month into the Miller's Trust, which saved you, $6,000 a month $7,000 a month on not having to pay for your long-term care. So the math works out in the end. There is not a 5-year look back on the Miller's Trust. So if you have too much income to qualify for Medicaid, we don't have to worry about that right now. We can worry about that at the last minute, to be honest. I don't say that often, but with this, it's the case. You're asset heavy. We have to worry about that now. You really need to act soon to get that 5-year clock ticking. Pitfalls to avoid. Let me just kind of sum it up this way. After somebody receives Medicaid, so if you have a widow and she goes into long-term care, she receives Medicaid for the nursing home, and they pay $180,000 out on her, and then she passes away. There's a group called MERP, which is Medicaid Recovery Program, Medicaid Estate Recovery Program. They're going to come after her estate after she dies to get reimbursed, so the state will get their money before the family. However, there's a little trick here that they can only get to that, the state can, if the estate goes through probate court. If we set up our estate to avoid probate court, which is what I recommend everybody do, period, anyways, even if this is not an issue for you, it's still a very good thing to do. We can avoid the estate recovery program at the tail end, and the family can get the house, the family can get whatever money is left. So very important. Please remember that. We want to set up your estate to avoid probate court, period. And one residual advantage of that is if you end up on Medicaid at some point. Also keep in mind that if you get married, even if you have a prenuptial agreement, let's say you could do a later in life marriage, it does not protect your assets from the Medicaid calculation. Medicaid is still going to calculate your income. They're still going to calculate your assets. So if you marry somebody later in life and then they have to go into nursing care and they don't have insurance, or they're not wealthy enough to pay for it on their own, I hate to say it, but you're kind of putting yourself on the hook, okay? Putting your assets on the hook there. There's also, like I told you, the 60-month look back, right? Medicaid always looks back 5 years at assets. And revocable trust to qualify for, does not help you qualify for Medicaid. To qualify for Medicaid, your assets must be in an irrevocable trust, not a revocable trust. Very important to remember. Another big problem that we see people having, another big mistake in estate planning, is people who do not have their funding updated, do not have proper funding. And what I mean by funding is this: if somebody sets up a trust, whether it's revocable or irrevocable, because they want to avoid probate court, maybe they want to qualify for Medicaid early, other reasons they can have, maybe they want to avoid the estate tax, maybe they want to not have their beneficiaries inherit the money all at once after they die, they want them to get it over a period of 10 or 15 years, something like that. You have to connect all of your assets to the trust. We call it funding, okay? But I like the word connecting. I think with more people that makes more kind of common sense. But you need to connect all your assets to your trust. It's unbelievable how many people I see who have a trust and none of their assets or half of their assets are connected. We're not avoiding court. We're not going to qualify for Medicaid. All these magical things that the trust can do, which, by the way, is avoid probate court, avoid the federal estate tax, treat beneficiaries different, giving them money out into time. Some other things we'll talk about: divorce protection, remarriage protection, Medicaid, nursing home protection. All of these things, if we don't have our assets properly connected into the trust, it's not going to work. So you have to keep the trust funded. Now, the magic is how you hold title to your assets. For people who have a trust and they have their assets connected to the trust, titled in the name of the trust, for example, all these magical things can happen. They cannot happen any other way. Again, avoid probate court when you pass away. Avoid the federal estate tax. Treat your beneficiaries different. Divorce protection, remarriage protection, Medicaid protection. These are all things that can only be achieved by the magical ability of the trust. Titled in trust equals no probate. That's just remember that. Very simple. Things that are titled, what are titled, right? Real estate is titled, stocks are titled, bonds are titled, financial accounts are titled, right? Personal assets are not, right? Personal assets are things that you own. It could be gold, it could be silver, it could be jewelry, it could be china, it could be antique furniture, things of value that don't carry a title. We don't have to worry about avoiding court with those. So a lot of folks, again, just lack of this kind of preparation, lack of funding can be a very common mistake. I can't tell you how many probates I've done where the person who passed away, they had a trust, they had 80–90% of their assets in trust, but 10 to 20% were not. And so they had to pay me to go to probate court. Now, still, it was kind of better because they did not have to probate the whole estate through the court system. 80–90% of it, they got it done quick. They got it done privately. But still, they had to come hire me and pay me to go through court because that person missed a thing or two. So it's another good reason for the updates every 2 years. Another big thing that we check on is to make sure that the trust is properly funded year in and year out. Mistake number 5, assets that completely bypass your estate plan. So there are things that we can do for somebody who doesn't have a trust. There are things that we can do to make sure that assets are going to pass without going through probate court and without having a trust. With all of your bank accounts, financial accounts, it doesn't matter if it's an IRA, a 401k, a checking account, a CD, you can go to your financial institution or your bank and you can ask for a death beneficiary, okay? A payable on death beneficiary or a transfer on death beneficiary, they call it different things. But if you get a death beneficiary set up, then that money can go directly to your beneficiary upon your death as soon as they've received your death certificate. So they may have to wait 4 weeks. It used to be 2 weeks in Texas. Now it's more like 4 weeks. And then they can go get your assets without going through the court system. So keep that in mind as well. There are things that we can do through joint tenancy with right of survivorship with real estate. We also more commonly nowadays are using a device called a transfer on death deed, where we can also leave our real estate to not just to our spouse who survives us, but to our kids as well. So joint tenants, right of survivorship, transfer on death deeds. These are things that we can look at for our real estate. With all of your retirement assets, your financial assets, again, you want to make sure that you either have these assets connected to a trust or you have them passing through a direct beneficiary designation. So we can avoid court, we can avoid a Medicaid lien, we can avoid creditors, people like that, people who we don't really care for. Mistake number 6, unsuitable planning for your family goals, okay? This is divorce and remarriage protection. And so not always, for sure, but most of the time, my clients want for their estate to stay in their bloodlines, okay? They want it to go from them to their spouse, to their children, to their grandkids. It's pretty clear. Here and there, there's a deviation from that, but most of the time that's the case. Divorce protection is this. It does not refer to you getting a divorce, the estate planner. It would refer to your beneficiaries getting a divorce. So in the state of Texas, and in most states, the marital laws state that if you received a gift or a inheritance during your marriage, when you leave that marriage, that gift or that inheritance belongs to you. You don't have to give 50% to your spouse. However, if you commingle it with your marital assets, meaning, okay, I inherited $500,000, I'll put some money in this joint account and some money in that joint account, and let's go buy a boat and put both our names on it. I've converted that into a marital asset, and that will be divided 50% for each spouse in the event of a divorce. Divorce protection is what we put into a trust that tells the beneficiary whatever money you haven't spent. Now you can spend your money, you can buy a purse, you can pay for the family to go to Disney World, but whatever money you have not spent, it is going to stay back in a trust account. It has to, that's the rule. And that way, if you end up in a divorce, guess what? It's clear as day to the divorce court that this is yours. You inherited it through the trust. You never commingled it. You leave the marriage with that money. Remarriage protection is a little different. This will refer to you, the person setting up the estate plan. This also must be done through a trust device. And this is where we want to protect against the scenario of one spouse dying, the surviving spouse getting remarried, which happens quite a bit, even when everybody says they never would do that. Oftentimes they do. And we want to avoid that new spouse worming their way into the estate plan and saying things like, well, I mean, I'm your wife now, or do you want to leave me destitute when you pass away? Do your kids really need all of that money? And you think, okay, well, okay, let's go see Brandon. I'll put you in the estate plan, right? It happens all the time. That is not what was intended when that man sat down with his wife, 10 years beforehand with me, the mother of his children. They were adamant. Everything goes to our kids when we're both gone. Now the new spouse comes in, things change. And I purposely use the analogy of the man, the wife dying first, the husband surviving and marrying the new lady, because that's normally when I see this. I honestly do not see the mothers coming in after the husband has died and adding a new man into the estate plan. That's super rare, super rare. But we see it when the husband is the survivor. It is not unusual to see that when he remarries. Okay, it's just kind of the way it is. I have my thoughts on why, but I'll keep that to myself. But it's what we see. So you ladies, you're the ones, if you're married, you need to be worried about this. If you pass away and your husband gets remarried, reasonable chance, no matter what he says, that new lady will be in his estate plan at some point. With remarriage protection and a trust, we can prevent that. We cannot allow that. Okay, once the first spouse dies, everything's done, locked down, everything's irrevocable. We're not adding in new people. We're also not allowed to give outsiders assets from the trust. So we can't just start stripping the trust of assets and saying, well, I'll just give this money to you now. We can't do that either. So some things that we can do there that can really help some families. Just distributing the assets to beneficiaries. This can be structured in a variety of ways. If you don't have a trust, if you're going to use a will, or if you're going to use beneficiary designations, direct beneficiary designations, your beneficiaries get the money as soon as they get done with that process, period. They get it all. Doesn't matter if they're strung out on crack or whatever, right? They're going to get that money. However, if you set up a trust, you can treat each beneficiary different, and you can custom tailor each beneficiary's distribution to that person and their personality. And there's plenty of people that, thank God, it's, well, my son's 40 and my daughter's 43 and they're doing good in the world, and when I die, they can have all the money. Okay, that's great. But there's plenty of other people, unfortunately, who have different issues going on with their adult children, and they're not comfortable with that. It could be chemical abuse, substance abuse, could be a rocky marriage, could be somebody that's just very undisciplined with money, no matter how old they are. So we can rein that in through the terms of the trust. And so this is something that helps out a lot of families. Okay. Okay. Mistake number 7. This is your family's unaware of your plan or their duties. Typically this is the males that tell me this. This is the husbands, but what's in my estate plan is nobody's business. It's not my kids' business. They can know about it when I die. And I'm just not telling them anything about it. Well, number one, they may not know where to find the estate plan when you die. I can't tell you how many times my clients have been through that, my probate clients, particularly when there's a blended marriage and the will conveniently just doesn't exist, even though the dad said it did. The new spouse, the new wife says, no, there's no will. He never said anything about that. And I searched the house and I can't find one. And the dad never gave the kids a copy, right? Because it wasn't their business. Seen that happen quite a few times. So your beneficiaries, they need to know how to access your estate plan, even if you don't want them to see it. And that's valid. I mean, you might want to, you might have things in your estate plan that would upset one of your children that are not included in this, or they're getting less money, and you don't want them to get angry at you. And so you want that to be private. You can still keep things pretty private, but at least let somebody know where your estate plan is, or give somebody a copy and tell them to keep it quiet and not share it with their siblings, right? So somebody needs to have a copy. Somebody needs to know where the original is. Doesn't mean you have to show everybody everything. You don't have to if you don't want to, but we need for people to be able to locate this in case you lose your mental capacity or you pass away. Again, you're rushed to the hospital. Can your family quickly access your medical powers of attorney, right? Your healthcare powers of attorney. If you're incapacitated, we have people like powers of attorney, successor trustees. Not only are they going to make medical decisions, they need to pay your bills. They need to manage your finances. They need to know how to access your recently updated powers of attorney. They need to know where those are so they can start doing their job. Same thing when you pass away, right? A lot of work that somebody's going to have to do after that happens. Again, when it comes to kids, and keep in mind, one of the big reasons to do estate planning, one of the big things I hear in my office is we really want to do this. We want to be very detailed because we do not want our kids fighting with each other after we're gone, or I don't want my kids fighting with my wife, who's their stepmom, after I'm gone. I hear this a lot. So we want to get that good estate planning in place. And if you know that there's going to be a big argument over it, pick somebody besides that person that's going to get angry to let them know where the plan is, or to give them a copy. Okay, so it's just, I mean, that's kind of common sense. Inventory of personal items. If you may have things that that maybe have a high resale value that other people don't even know, right? Like antiques, for example, different items of jewelry that somebody may just at first glance not know is actually has a high value. So you might want to leave a list behind of items, personal items, non-titled items that have a high financial value. So those aren't overlooked and just randomly sold in an estate sale for a little bit of money or given to Goodwill or something like that. Also, if you have multiple children and you're afraid they may argue over, if you have 2 daughters and you're going to be leaving your jewelry behind and you're afraid they may get in an argument over that, you may want to designate who gets what, or if you're the father and you have sons, you have a gun collection. So I have a lot of clients who do not itemize their personal property at all. They're just say, look, when I go, they can get it, they can split it up, they can sell it, whatever they want to do. I have other clients that are real into it and that they have several things that they really just want to itemize and they want to leave to certain people. So it just depends on the individual, really. Arrange a meeting to discuss your plan. Great thing to do. It does not mean you have to tell everybody every detail of your plan if you're afraid that will cause a family argument. But let people know, let all your kids know at once that we have a plan. This is where we keep it. And Brandon McGee is our attorney. If something happens to us, you need to get this plan and you need to go see Brandon and he will tell you what to do. I also invite, when my clients come in to sign things and to have funding meetings, they sign their documents. I'll tell them, if you have local adult children that live here locally, invite them to come in. If they're not too busy, have them come in. They can watch the signing. They can meet me. We can discuss a little bit about what you have. So it's really important to do that. And I think in an ideal world, your adult children, at least one of them, will meet the legal practitioner who prepared the document. So they'll know who that person is. They'll know who to go to when the time comes. Mistake number 6, estate planning, leaving out life lessons, family history, things like that. So look, a lot of people, when we think of estate planning, we just think of money. We're hyper focused on money and assets and taxes. And that's all I've talked about, right? Pretty much from start to finish. And so it's me too. I'm also that person. But the reality is, in life, thank God we're leaving behind more than just a dollar figure. I'm not Brandon McGee. He was X dollar figure and now he's dead, right? That's almost how estate planning feels sometimes. But the reality is we are leaving behavioral norms behind. We are leaving a family history behind. We are leaving ethical and moral values behind. We are leaving, spiritual and religious views behind, viewpoints on the world, things like that. And so each of our clients has a binder at the end of the process, has all their documents in it. They have a USB card with all of their documents in the PDF digital format. And then at the end, they also have, each spouse has a workbook. So it's a life workbook where you just go through and you answer a bunch of questions. And when you're done answering these questions, you have left a biography of your life. You have left information about your family tree, your family history, and information and things that, whether it's religious verses or just ethical and moral viewpoints that you want to leave to future generations that you think are important, those can all be left behind. And we think that's real critical. Okay. So real quick, let me tell you this, and then we'll get to question and answer. Like I told you earlier, I feel very strongly everybody, including a man under a bridge, should have the set of powers of attorney. We have 7 in our office. A last will and testament. I think everybody should have that, if nothing else. From there, a lot of my clients choose to seek court avoidance, probate court avoidance. So they may pick a trust, either revocable or irrevocable, depending on the circumstances, or they may pick to use beneficiary designations instead of a trust. But we want to have those last will and testaments to avoid court in the event that we lose our mental capacity, so our family does not have to become our legal guardian. We want to have at least a will behind to get through court quicker and cheaper and less stressful if we have done nothing else. But then we want to explore just total court avoidance. And there's, like I said, there's different ways to do it. And then we also want to take a look at preparing for the cost of long-term care. How can we get set up to make sure that if that happens to you or your spouse or your parent, that you already have a plan in place and the family just has to follow the plan and not be running around in a crazy emotional whirlwind, scared to death of losing all your money. So those are the things that we plan for here at the McGee Law Firm. I want to let you guys know we do offer a complimentary initial consultation, and be happy to meet with any or all of you. And it's for up to 1 hour. So I do not charge you for the first hour of my time. Past that, if you want to do business with us, we love it. We enjoy it. If you don't, that's fine too. We're still friends. So, but thank you guys for listening. And I'm going to turn it over to Zoe so she can tell me what the questions are and I can answer them.
Perfect. Yes. So, I do see, so we have someone that asked if they have a grave site that has been paid for, will that affect anything as far as their Medicaid planning? Will the state take it, or how does that work?
No, that's a good question. So if you have burial and funeral plans, it could be cremation. So this could be anything from owning the dirt that you're going to be in, to already having prepaid the funeral and the burial, to prepaying for cremation. Medicaid will not make you liquidate that prior to applying. However, it needs to be irrevocable, meaning you can't go back and say, hey, time out, I want all my money back, give me my money back. It's real easy to make it irrevocable if it's not. We've had different Medicaid application clients over the years. You just go back to that company and you say, look, I have this plot with you, or I have this plan, it's revocable. Can we draw up a new contract making it irrevocable? They are more than happy to accommodate that, because that means you can never come ask for your money back, right? But yes, that is off limits, thank God, for Medicaid, and it needs to be irrevocable.
Okay. Okay. That makes a lot of sense. Any other questions, guys, that you have for Brandon today? And also, I only just talked to Brandon about this right before we started this, but I'm going to tease it. We're going to work on, if any of you would like to meet with him in person, on having him be here at the spot in Richardson. If traveling to Fort Worth is a little far and you don't want to do it on Zoom, but we're going to put together a plan to make that happen if anyone would like to meet him over here. So
yeah, absolutely, guys. So we'll work on that, and I'd be happy to come over to the east side of the Metroplex here and there and meet with you guys.
Yeah, great. All right, guys. Well, it looks like that's all we've got for today. I don't see any other questions. Brandon, thank you so much for joining us today. We really appreciate your time. Everyone, if you would like to take yourselves off mute, you are more than welcome. Make a little bit of noise for Brandon. So
Thank you.
Thank you.
Thank you
Thank
very
you,
much.
guys.